Now we'd like to start the panel discussion. The first theme is international trends in the field of intellectual property, as well as the roles of the IP courts. Now we'd like to introduce panelists. Mr. Minoru Masuda, the President Judge of the IPHC. Mr. Matsuo Nonaka, the Chief of the Appeal Department of the JPO. Mr. Han Gyu-hyun, the Chief Justice of Korean IPHC. Mr. Klaus Grambisky, the President of the Court of Appeal of EUPC. Mr. Raymond Chen, the Judge of the U.S. Court of Appeals for the Federal Circuit Court. Mr. Yuriko Sagawa, the Attorney of Law from Nakamura Patent and Law Office. Mr. Megumu Kurokawa, the Patent Attorney of Abe, Ikubo, and Katayama Law Office. And Mr. Naoki Iwai, the Judge of the IPHC. These are all the panelists for today's session. Now I want to hand over to Mr. Iwai as a moderator for this session. Thank you so much. Again, now we'd like to begin the plenary panel discussion. The first theme is international trends in the field of IP. First, I'd like to invite the judges joining us from overseas to each take about 10 minutes or so to introduce recent developments in their respective courts. Now, I'd like to invite Mr. Han.
minasan konnichiwa.
Thank you so much for coming here. I'm very happy to see you in person. I am Han Kyu-hyun, the Chief Judge of IP High Court of Korea. Mr. Watanabe. And all the guests, thank you very much for giving me this opportunity to be here to celebrate the 20th anniversary of the JPHC. I'm very happy to be a part of this panel discussion in the Symposium. Now, I want to look back the 20th history of the IP High Court function in Korea. So related to the protection of assets, I want to share something. In the South Korea, in the Constitution, the rights of authors, inventors, scientists, engineers, and artists shall be protected by Act, which is 22. So, based on these constitutions, IP Judicial has been developed in a sustainable manner. So, the major milestones in Korean IP legal system back in 1998, the first IP High Court was launched in Asia for the first time. In 2002, we have introduced special forum for IP cases. In 2022, we introduced electronic case filing. And in 2011, we introduced orders to maintain confidentiality. And in 2015, IP Hub Court was promoted. And in 2016, the consular jurisdiction over civil appeals, and submissions of material are ordered. And in 2017, the Intellectual IP Law Research Center was also launched. In 2018, the International Division was introduced. And in 2019, obligation to present specific type of behaviors and enhanced damages were enacted. And in 2021, the video hearings were expanded. And we have a dedicated, so I want to talk about the patent litigation mainly here in the judicial restructure. So we have a Supreme Court, and for civil case, that will be the third state. Also, in the second state, the instance is dealing with the IP High Court, and actually we have 6 jurisdictions. Overall, nationally, we have 6 district courts. Now we have 4 IP functions operated since now we have 13 judges and 11 judicial technical advisors. And civil, and they have rights to deal with the appealing cases. And we have 17 judges and 22 judicial technical advisors. And for the final appeal, we have 4 judges in 3 smaller forums, and the head of Supreme Court. And so we have a group of 12 people, judges eventually. And for also we have 6 IP dedicated judge researchers and 6 technical examiners as well. Next, I want to share some digital environment advanced as well as international infrastructure. In case of ecosystem, that was launched in 2010 as innovation cases, and in 2011, all the civil cases have been expanded too. And this year, this e-filing, all the cases can be filed using digital. The stakeholders can save their time, and they do not have to be restricted by place, and they have access to any evidence in real time. Also, they can submit like source codes, drawings, and videos. They are all in the format of digital for their submission. At the top, you see 2 pictures. This is the scene of a court with digital environment on the left-hand side, or the bottom left, this is an e-record viewer. Again, so far, like video hearings, hearings have been activated based on our dedicated preparation in 2011. Because of this initiative, not only domestic but also international parties can join like a remote proceedings. So this picture, this is about the video hearings. And for the international, so in 2018 in Seoul, District Court, now their international division was launched. Here, English or foreign languages are available, and also documents in foreign languages could be also translated, and simultaneous interpretations and official translations are also available. International parties can use their mother tongues to have communications with the international division. So also they could join the web court remotely. On the September 24th, according to the patent law or judge, So international parties can join that proceedings remotely. So there is a improved proximity. So the ability of the court and international competition could be enhanced based on the IP specialized and court and IP specialized divisions. And they release international information, and the main decisions are also available in English. And that is also publicized in the web. So also for more effective proceedings, they have dedicated technical experts. So they have more specialty dedicated. Since 2016, we have introduced the judges for the guideline so that judges' specialty could be further enhanced. And in order to understand ethical perspective, like a technical advisors, expert witness could work together with them. So they are specialists in many fields. In particular, like a technical experts, like a patent, they support the technical aspect for the patent, for example, so that they can share any insights into the questions asked. So now, if we could not solve any high advanced patent dispute, we can invite external parties. Dedicated experts are specialists in many fields. So there are 781 professional examiners as a pool. So they could explain the reasoning. Also, they could ask questions if necessary. In some cases, in order for judges to understand technical aspect, they could invite them as witnesses. So the court, again, for better proceedings, for infringement cases, for example, they could issue orders to maintain confidentiality to submit materials. Like if documents with confidentiality, then based on the request from the parties, the counterparts can be requested to keep their confidentiality. Also, based on the application from the stakeholders, they could also request for documents that will be used to calculate the level of loss. And also, party to lawsuit filed against infringement of a patent or an exclusive license who denies a specific content, manner, and form of an infringement as claimed by the patentee or exclusive licensee shall present his or her own specific type of behavior. Also, they can check the level of the consideration so that against intentional infringement, up to 3 times of compensatory damages could be requested. Actually, it was updated to 5 times last year. And in 2016, the rules of the practice was launched, but that was all revised on the July 11th in 2025. So regarding orders for document submission, all the details were clarified. And there is a now standard procedure so that complexity can be eliminated and predictability can be upgraded in the court. Recently, in the revocation of infringement, the request for appeal can be enhanced. So in the South Korea, because of the emerging technologies, many challenges are being tracked and overcome so that a global level of IP litigation will be possible. And that's all from me regarding the IP jurisdiction history in the last 20 years, including the development in South Korea. Thank you so much.
Thank you very much, Mr. Han. Next, I would like to call upon Dr. Grabinsky, the President of the United States Patent Court, the Court of Appeals.
Good afternoon. It's a pleasure being here in Japan, and I'd like to take the opportunity to congratulate the IP High Court to its 20th anniversary. I'm the president of the Unified Patent Court. It opened its doors just a little more than 2 years ago. So in terms of a human being, the IP High Court is a strong young adult, while the UPC is still a little toddler. So we can learn a lot from the IP High Court at the UPC, I'm sure about this. Let me start giving you an update of the Unified Patent Court as it stands right now. The Unified Patent Court is a court common to currently 18 EU member states. So unlike a classical court that is a court for one country, this court is a court for currently 18 EU member states. In other words, I could say it is the court of Austria, it's the court of Belgium, and I could name all the 18 member states that take part in this court. On this slide, you see a map of Europe, and you see all the UPC member states in the dark blue color. You see also the medium blue color. These are EU member states that have signed the UPC agreement, but yet have not yet ratified the agreement. And then you see more EU member states in a light blue color. These are the states that have neither signed nor ratified the agreement, but they are all invited to join the Unified Patent Court if they like. Here you see the structure of the UPC. It has a court of first instance with currently 13 local divisions spread all over the UPC member states. It has a central division that has its seat in Paris and has sections in Milan and in Munich. And it has one regional division, which is a division that is shared by 4 UPC member states, the Nordic-Baltic division, and there, by the way, the language of proceedings is only English, but I come back to the languages in a second. There's a Court of Appeal, and I'm the president of the Court of Appeal that is located in Luxembourg. And like any other court in the EU national court, also the UPC has or may make referrals when it comes to the interpretation of EU law to the European Court of Justice, when it is relevant for deciding the case and the questions are not clear or clarified by CJEU decisions. And there, this system is also complemented by a patent mediation arbitration center, which is called the PMAC. It is currently not operational, but it will be operational very soon next year. So all preparations are on track in that regard. What about the jurisdiction? Let me first address the subject matter that the court has jurisdiction on. It is about infringement and the validity of European patents, classical European patents. As you may know, they are bundled patents. Once they are granted, they give the effect like a national patent in all the member states of the European Patent Convention, provided the European patent has not been opted out. And it has also jurisdiction on the so-called unitary patent, which give unitary effect in the UPC member states. What about international jurisdictions? And that is currently much debated, so that's why I like to focus a bit on this issue. The UPC has jurisdiction in case it is about infringement, alleged infringement of a European patent in a UPC member state. So the infringement occurred, for example, in Germany, then it is clear that the UPC has jurisdiction in that situation, provided, of course, the patent has not been opted out. But it has also jurisdiction when the seat of the defendant is located in a UPC member state. And in this situation, for example, a company located in Germany, and in this situation, it is not only about infringement that occurred in the UPC member states, but it can also be infringement in other states of the European Patent Convention. For example, in Spain, which is not a UPC member state, but an EU member state, or for example, in UK, which is not an EU member state. And the court, under certain conditions, has also international jurisdiction when it is about a number of defendants, and only one of these defendants has its seat in the UPC member states, provided the claims are so closely connected that it is expedient to hear and decide the claims together to avoid the risk of irreconcilable judgments. And there are currently two decisions of the European Court of Justice that further clarify when there is such a close connection. But I'm not going into details because to save time. Now, the court has jurisdiction on infringement, but the court has also jurisdiction on revocation actions when it is about putting the validity of the patent into question with effect to everyone, erga omnes. But only when it is about the UPC member states, so to the extent that the European patent gives protection in the UPC member states. The UPC has no jurisdiction with regard to revocation actions to the extent a European patent gives protection in non-UPC member states. So what can the defendant in infringement action do when he or she wants to defend him or herself with regard to parts of a European patent that give protection outside the UPC countries? In that regard, one has to distinguish between EU member states that are non-UPC member states like Spain and countries that are no EU member states like, for example, the UK. In both situations, the defendant will have to file a revocation action in the respective national courts, so in the Spanish court or in the UK court. And what will be the effect for the infringement action that is pending in the UPC, for example, because the defendant has its seat in the UPC member state? In that situation, the UPC may think of staying proceedings in the UPC with regard, for example, to a revocation pending in the Spanish court, or with regard to a revocation pending in the UK court. However, the UPC has also jurisdiction to decide, not erga omnes, not with effect to everyone, not on a revocation action, but as a defense on the validity of a European patent with regard to countries that are not EU member states. And this has been clarified, what I explained to you, by a decision of the European Court of Justice that came out on the 25th of February of this year, and is currently very much debated what this means in all the details. And we already have some decisions of the Court of First Instance of the UPC, and we will further have to work on this and find out about this. Let me move on with regards to the numbers of actions that have been brought to the UPC. As you can see, between 1st June 2023 and 31st August 2025, 773 cases have been filed in the Court of First Instance. And a large part of these claims are, of course, actions for infringement, but also we have seen filing of counterclaims for revocation, actions for revocations, and also requests for provisional measures, in particular provisional injunctions. Let me continue with the composition of the panels that are deciding. There are two characteristics. The one is that the panels, as to the legally qualified judges, is always composed international, meaning the judges coming from different countries. And that, of course, is in line with the idea of the UPC as a court shared by a number of member states. And the second point I would like to mention is that in most of the cases, the legally qualified judges are joined by a technically qualified judge. So that is different, as far as I understand the system here in Japan with the IP High Court, where there are technical advisors. In the UPC, they are judges. So they have a voting right like a legally qualified judge. And they have a background either as a national technically qualified judge, there are some countries that have national technically qualified judges, or they can be practitioners, meaning patent attorneys, or they can be retired members of boards of appeal of the EPO, for example. And with regard to practitioners, there is it's always made sure that there is no conflict of interest. I'm not going to details, but this is always checked before a technically qualified judge is assigned to a panel. Final point I'd like to make is about language of proceedings. Well, this is an international court, and in Europe we have many languages. In principle, all the local divisions offer to the claimant the choice either between the local official language, for example, if it is the local division in Paris, then the claimant can choose French, or, and this is true for all the local divisions, alternatively English. So if you go to a German division in Munich, it is German or English. In Paris, it is French or English. And in Milan, it is Italian or English. What does it mean in practice? That you can see from this slide. You see the pie, and you see that English is by far the most important language used as language of proceedings. However, German also plays a significant role, and there are a few more languages that are used, but not that often. And if I should tell you about a trend, I could say that it is currently becoming more and more English as a language of proceedings, and the part of the German proceedings is decreasing slowly, but it is decreasing. And this is quite interesting because all the member states, none of the current participating member states has English as an official language. So that gets everyone on the same level playing field. And that is, gives you an idea, this slide, about how the local divisions or the courts look like. In the first row, you see the regional division in the building of the regional division in Stockholm. Second is the building where the Vienna local division is located. Next one is where the Hamburg local division is located. Next one, you may guess, it is the local and central division in Paris. The middle one is the Court of Appeal in Luxembourg, a bit futuristic building. And finally, it is the local division and central division in Milan. And with this, I'd like to conclude my talk. Thank you very much.
Thank you very much, Dr. Grabinski. Now I'd like to invite Judge Raymond Chen from U.S. Federal Circuit.
Konnichiwa. Thank you. I want to give my thanks to the hosts and organizers of today's conference, the Supreme Court of Japan, the IP High Court, the Ministry of Justice, JPO, and the lawyer groups. It's my honor to be here as the representative of the U.S. Court of Appeals for the Federal Circuit. And congratulations to the IP High Court on their 20th anniversary. We understand that this is not just a world-class economy in Japan, but it's also an important center of innovation. And so it's essential not only to Japan, but also everyone that Japan have an effective set of IP laws and enforcement of those IP laws. So I congratulate the IP High Court, and I look forward to seeing and watching your continued success. Now, the Court of Appeals for the Federal Circuit is now 43 years old. So if I can borrow President Grabinski's analogy, if the UPC is like a little toddler and the IP High Court is like a young, strong adult, we, the Federal Circuit, are like a middle-aged man with perhaps getting a round, soft tummy. Maybe we have some maturity, but it's also important for us to be mindful of needing to adapt to change, and there has been quite a bit of change. As for the Federal Circuit itself, it hasn't really structurally changed very much in the past 43 years. We continue to have 12 active full-time judges and a handful of senior judges that work a part-time schedule. Just as in 1982, the Federal Circuit has exclusive nationwide jurisdiction, appellate jurisdiction over patent law, which means if there's a trial, a patent infringement trial in Seattle or Los Angeles or Dallas or Chicago or Atlanta or Washington, D.C., the appeal will not go to one of our regional circuits. Instead, the appeal of that patent infringement action, they will all come to Washington, D.C., to the Federal Circuit. And likewise, we at the Federal Circuit also hear appeals directly from the USPTO administrative boards, both the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board. So in this way, the Federal Circuit looks very similar to Japan's IP High Court. But over the past 20 years, the United States has experienced a considerable amount of change in its patent laws. I think if an American patent lawyer went to sleep in 2005 and woke up today, I don't think that American patent lawyer would recognize the patent system in the United States. I'll highlight a few key developments. I'm already running out of time. The first really crucial thing I think that's important for an international audience to understand is that our Supreme Court has become re-engaged with intellectual property law matters over the past 20 years. If you look at the first 20 years of the Federal Circuit's existence, really 23 years, from 1982 to 2005, the Supreme Court was not engaged in intellectual property law issues at all, really. And we could wonder why that is so, but I think part of the reason was because the Supreme Court saw there was a brand new specialized appellate court called the Federal Circuit that was going to be handling patent law issues and wanted to wait and see and give room and time for the Federal Circuit to develop a nationwide uniform body of patent law. I think a second reason is probably that the Supreme Court came to recognize about 20 years ago how important and consequential patents are and intellectual property is to the economy and really to American society. And so for those kinds of reasons, about 20 years ago, the Supreme Court got involved. And I think the first case I want to highlight is the eBay versus Merck Exchange case. This is the Supreme Court case 19 years ago that ended the presumption of permanent injunctions for patent owners who prevailed in a patent infringement lawsuit. Now trial courts apply the traditional equity factors that apply any time a plaintiff in a American lawsuit is seeking an injunction. And so this applies not just in patent cases, but any injunction case. So as you can see on the slide, it's irreparable injury, whether the plaintiff has inadequate legal remedies, the balance of hardships between the plaintiff and defendant, and what is in the public interest. And now with these factors in consideration, the result has been much fewer injunctions are now granted in the United States, even when a plaintiff in a patent infringement lawsuit wins an infringement verdict and survives a validity challenge, particularly when the plaintiff is not practicing its own patented technology. In those particular circumstances, when the plaintiff is a quote-unquote non-practicing entity, it's very unlikely that such a plaintiff can get an injunction. And this has really changed the dynamic between plaintiffs and defendants, just in terms of trying to negotiate settlements. As you may know, really only 1% of all patent infringement lawsuits ultimately go to trial in the United States. They almost all settle. And so now the settlement equation since eBay has changed somewhat. And then the KSR opinion, I'm already almost out of time, is about non-obviousness. I think other jurisdictions might call it inventive step. And once again, the Federal Circuit had a very bright line rule, just as it had with injunctions. In the Federal Circuit for the longest time would grant an injunction or would uphold an injunction for any plaintiff in a patent infringement lawsuit that won at trial. Now, thanks to eBay, it's not rare, but it's much less common. And then KSR, the Federal Circuit had a bright line rule, a bright line test for assessing obviousness. And what the Supreme Court did is say, no, we don't want any bright line tests. We want a more flexible inquiry, and that was KSR. This is another critical substantive area of patent law, patent eligibility. As you can see, the Supreme Court took 4 cases in a very short period of time, and that is highly unusual for the Supreme Court to take any one particular area of the law and then repeatedly consider it in just a period of 4 years. And what we have now is what I'll call the abstract idea test, where we now have to ask ourselves, for purposes of whether a patent claim is even eligible for the patent system, is the claim directed to an abstract idea, or is the claim directed to an inventive concept? I don't have the time right now to try to explain all of that. It's actually very complicated and controversial. But what I will tell you is that when district courts evaluate a Section 101 question for a patent claim, those district court decisions generally do get affirmed by the Federal Circuit. So at least the courts seem to have a basic understanding on how to apply this new area of the law, but it's still very controversial in the United States. And so the theme here with the Supreme Court is that, as I said earlier, the Supreme Court does not want the law to have a lot of bright line rules. The Supreme Court has a different philosophy when it comes to approach to the development of the law, whether it's patent law or any other area of the law. They want courts to use and apply flexible factors and other considerations and use their judgment in order to decide any one particular case. And I think district court judges, Federal Circuit judges can handle that okay, but it's the 8,000 patent examiners that have a much harder time in trying to deal with this new trend in Supreme Court law and Supreme Court intervention in US patent law. I'm out of time, but I can't ignore these cancellation proceedings that are at the PTAB now at the USPTO. These were created in 2011 by Congress, and they've been extremely popular in the United States for companies to challenge other patents through these administrative cancellation proceedings. As you can see, a lot of these proceedings have ended up invalidating a lot of patents in the United States, and so it's been a new weapon for defendants. But I think what we've also learned from these cancellation proceedings is that maybe we need the USPTO to do a better job of initial examination. Now, this is not an appropriate statistic to use to try to judge the quality of United States patents, because there's a lot of factors that get mixed in, but nevertheless, it's a little bit of a window on why, in my opinion, the USPTO should try to focus more, and maybe with the advent of AI with examination processes, perhaps that'll be an improvement. But the one warning I want to say is that the new administration at the USPTO has been clearly this year looking to deny more of these types of proceedings. And what the result of that will be is really to force more defendants to have to seek to invalidate patents in district court rather than through the USPTO, unless a party wants to use a re-examination, which still is a viable option. There's a concentration of patent litigation. I think most people understand this. Most lawsuits are filed either in Texas, California, or Delaware. I think there's advantages to that because judges in those districts accumulate a lot of knowledge and experience with patent law, but there are dangers when you concentrate cases in just a few areas because you're always worried about bias and things like that for certain district courts to try to attract cases. And then finally, modernizing operations. Just like every other court around the world, we now use electronic filing. We do permit video arguments at times, and we in the US judiciary are thinking and talking with each other about AI and what generative AI means for us inside the courts, AI-generated evidence that can be introduced in litigation, and whether AI, like I said, can help improve patent examination. I'll stop there. Thank you very much.
So, Mr. Chin, thank you so much. So, everyone, thank you very much for such a great presentations. Now, we want to spend 30 minutes plus for discussions and opinion exchange. First, having reviewed the activities of the IP High Court of Japan, the Japan Patent Office, and overseas courts over the past 20 years, we'd like to hear comments from the user's perspective from Mr. Sagara, attorney at law, and Mr. Kurokawa, patent attorney. So, Mr. Sagara, may I invite you to begin? Thank you so much. Yeah, together with Japan law, as a part of the JFBA Intellectual Property Center and the Japan Lawyers Network for Intellectual Property, I want to honor of hosting the JSIP together with the IP High Court. Thank you so much for your continued great support for this kind of event. Through my involvement, I have come to appreciate how demanding it is to organize an international conference of this scale every year. That is a really great progress in the last 20 years. As a user, I've been feeling progresses in many fields. First of all, in particular, the acceleration and enrichment of appeal proceedings against JPO decision, that is one particular progress I've been feeling. As Gravinsky-san, Mr. Chen said, I'm probably a little older but still young lawyer. Actually, my real age may not be so young, but before IP High Court was launched, I experienced it. But at that time, it was said that, judgments in appeals against JPO decision arrive long after you've forgotten about them. But now, it takes only 7 to 10 months. And now, mutual parties can use PowerPoints for technical explanations, which is very common now. So now it is much smarter proceedings, and you see much improvement in proceeding as well. And the second point, again, website information disclosure improvement. In almost all cases, I would say, they are timely disclosed. And regarding critical cases, information is available in Japanese and English as well. This is really appreciated and a wonderful initiative. Because of this type of information disclosure, the transparency of decisions by court is better. Also, digitalization has been progress in last few years, and the digital actually gives very big impact to the field. Because of the new business court, now it is possible to do scheduling on the web, which also accelerates the proceedings. And also, now we are going to use the e-filing. So I hope that we can have much better, faster convenience according to the code from each region. Thank you so much for presentations. In Korea, for example, digitalization is really remarkable. So international division was launched. Also, the introduction of a punitive damages system allowing up to 5-fold compensation, and such kind of implementation is really speedy. I was very impressed. Also, in the UPC, so you need to have some harmonization of interest across different countries, and I really show my respect to that great efforts. Already 773 cases have been continued already after the launch of UPC. Even in Japan, I really feel such activation. That is really speeding proceedings, as I have heard. So I believe that you're going to have more accumulation of cases, which I want to keep monitoring. In the U.S., like a discovery, jury trials, which are very different from the structure in Japan. And I was pretty interested in them. Like digitalization has been progressed, but at the same time, the in-person proceeding is still respected. So for us to make progress in digitalization, this is something I can learn. Also, utilization of AI has been already shared in the U.S. presentation. That is another impressive thing to me. That's all from me. Thank you. Ms. Sagara, thank you. Now I want to invite Mr. Kurokawa, the patent attorney. Thank you so much. I had the privilege of serving as a judicial research official for 3 years, beginning 6 months before the establishment of the IP High Court. So I want to say congratulations on the 20th anniversary. I'm very happy to be able to make my comments here. So at that time, every day almost, like both domestic and international, many visitors came to observe the court. And we got so much encouragement there. To respond to such encouragement, we've been working on our duties in a meticulous manner. After my term, I have continued to engage with the court as a user, and I'm deeply grateful for its swift, detailed, and highly predictable judgments. Because technologies are more advanced, again, swift and precise decisions are really very appreciated because we can get more predictability. I understand that the grand panel cases require great effort in both selection and deliberation. But still, looking back last 20 years, there are 16 cases decided, which is a very high-speed pace. And among them, sometimes there's some impact to JPO practice, for example, like support requirements or amendment requirements. They show their specific guidelines, and that's why usability, practicality for users have been enhanced. Regarding the initiatives about JPO, like faster improvement of proceedings, international harmony, many activities were done to achieve their target. I want to show my respect to that. In any initiatives, including users' comments such as Japan Patent Attorney Associations are highly listened to. I really appreciate it. In each region, I got the update. In Korea, South Korea, rapid and bold reforms such as electronic litigation system have been implemented. I'm pretty surprised. For users, like e-record viewer, for example, this is really, really convenient tool. In the UPC, first of all, overcoming many challenges, I want to show my respect to the establishment of such unified function. For many Japanese companies, English usage is really convenient for the court. Also, the ability to litigate in English and switch to expert judgments of the UPC would be really beneficial to many Japanese businesses. In the US, as introduced, all decisions showed a flexible approach to obviousness, for example. Also, in IPR, BGR introduction together with PW would show more selections, options to users, and this would be really effective for the validation of validity of patent. Lastly, through the JSIP, we want to continue this kind of international exchange. Again, we would work with the international organization for further exchange. That's all from me. Thank you so much. Mr. Kurokawa, thank you so much. Panelists, again, thank you very much for your great comments and information to us. Also, thank you very much for coming here to celebrate the 20th anniversary of this function. Now, we don't have much time left, so now we want to move to the next theme.
So we like to move on to the next theme. Role that IP specialist court has to play. So here we like to hear from the panelists. As regards IP specialist court, what kind of role that IP specialist court has to play? So this is a big theme. But for this theme, so this will be discussed in day 2 as well, the JPO part and also court part. We are going to again discuss the IP special court's the role. When it comes to IP fields, that involves various fields. But in this panel discussion, we like to focus on patent. As for Mr. Nonaka, so IP administration, JPO has to play. And Mr. Sagara, Mr. Kurokawa made the comments from the user's point of view. So we like to call upon Mr. Master of IP High Court. My name is Master from IP High Court. At the beginning of this panel discussion, as Mr. Honda, Chief Judge of IP High Court, made a keynote speech on the part of IP High Court, since the establishment, we are aiming for the prompt and appropriate decision and make efforts to as a role of the standard setter. As for this, so from judges from each jurisdiction reported the history of the last 20 years, but various jurisdictions adapting themselves to the changing the environment. So IP High Court is handling the highly technical cases. We have to be expected to have high expertise, and the advancement of technology is accelerating. So that requirement or that expectation is gaining more importance. According to Mr. Han, as on the part of IP High Court of Korea, so they have a similar system like our judicial research official or technical advisors, and they are using the expert witness as well. According to Dr. Grabinski, UPC's panel includes the technically qualified judges. So looking at those systems, it shows that we have to have a high technical expertise. So on the part of IP High Court, we have judicial research official system and technical advisor system, as Mr. Honda mentioned. So those systems are needed for us to be able to make appropriate decision. But still, there is a room for the improvement. As for this discussion, so we'd like to have a discussion in day 2, court part as well. So we would like to have a deep dive discussion tomorrow. So IP cases which might potentially have a big impact on the society and economy. So we have to think about the social impacts that our decision will have. On the part of IP High Court, apart from the usual panel, 3 judges, but we have a 5 judges grand panel system. So by this having this system, so we think that we are making a very discreet and a decision, and they play a role of the standard setter. So and also we are using the third party opinion system. So this is an opportunity for us to consider what kind of impact that the decision will have on the society. As for the third party opinion system, so in the day 2 court part, we are going to discuss again amicus curiae or third party opinion systems. Lastly, as for the trend of the digitization, that has to be mentioned. As Mr. Honda mentioned, in our courts, so we are making efforts to the further digitization and utilization of digital the technology, as according to Mr. Han. So Korea digitization is highly advanced. So there is a lot of things that we have done from Korea, especially the IP codes. We have to revert to the expectation of the rapidly changing society. So in order for us to be able to do that, so courts and the court officials and judges have to act as a one team in order to live up to the expectation of the users and the society. Thank you very much. So we like to have opinions from the international guests as regards the role that IP Special Court has to play. So Mr. Han, please. As for the role IP Special Court has to play, as you might know, so courts always have to make appropriate decision, a prompt decision. The same goes to the IP Special Courts as well. From about the IP High Court, it's handling highly technical cases. But IP High Court, so its decision has the significant impact on the society and the economy. So we have to contribute to the growth of the society and economy as well. So we have to have understanding about the current situation of the society and economy, so that we can make a decision from the viewpoint of the economy and society as well. In that way, we might be able, we could contribute to the enrichment of the lives of our citizens. And we have to make sure that rights of the right holder and also people have to be assured. So we have to strike a good balance between the protection and meaning that the enforcement, and also the user who would like to use such a technology. And also, we have to have a predictability so that the company will be able to make a appropriate strategy by predicting what kind of decision that the court will hand down. So ultimately, we have to be able to contribute to the growth of the society and the economy. And the IP is an international field, so I would like to emphasize the international exchange is really important and share our experience and practice. And there is a lot of things that we have done from the other countries so that we can be prepared for the future. That concludes my comment. Thank you very much.
Thank you, Mr. Han. Now I'd like to invite Judge Chen from US. And so I'd like to hear your opinion on the rules for the IP High Court.
Hello? Okay, thank you. The role of intellectual property specialized courts, it's a complicated question, but I think one of the first things we have to think about is the way we are able to communicate our opinions effectively to the public and also to all the other courts. Because the other courts in the United States are all generalist courts that read our opinions, like the district courts and the Supreme Court. So in many ways, I think it's important for a specialized court which understands the technical areas of their subject matter very, very well, that such a court is at the same time able to communicate all of that technical legal subject matter to generalists that are not specialized in this same area. And I'm talking about patent law right now. So that's an important responsibility because it seems like when you look at the recent history of Supreme Court reversals of Federal Circuit opinions, perhaps one of the problems there was that the Federal Circuit failed to effectively communicate the reasons for why the law developed the way it had at the Federal Circuit from 1982 to 2005, and therefore the Supreme Court couldn't completely appreciate the intentions and point of view of the Federal Circuit. So I think being able to be an effective communicator and getting into a dialogue with the generalist courts and as well as the public matters, and then for that matter, the USPTO. USPTO has a huge responsibility, as I said. They receive hundreds of thousands of patent applications a year. They have thousands of patent examiners. Very few of them have law degrees. So as a Federal Circuit judge, we have to keep in mind that the more complicated we make the law, the harder it will be for the USPTO to administer that law inside the agency. So I think that's an important sensitivity. In terms of larger policy goals of trying to decide how best to promote the economy or how best to promote innovation, I think that is something that the Federal Circuit is sensitive to, and we, I think, did have some kind of a role in why the United States economy improved after the creation of the Federal Circuit. I think A lot of people believe that. But at the same time, what's more important, I think, is the rule of law. It's our responsibility to follow precedent and apply it regularly with uniformity and predictability. And then if the true policymakers, which are members of Congress, see a problem with that precedent, then they have the opportunity and perhaps responsibility then to reform the laws to put patent law in a better direction. And in a way, the Supreme Court also has that responsibility as well. The Federal Circuit does have some discretion, I'll say, when they act as a full court to revise the law if they see that the law is not going in the correct direction or in the direction that the Federal Circuit had originally intended. But at the same time, it's important for a specialized court to also have some humility and not writing opinions too broadly, because opinions that we issue have nationwide consequence. We don't have other circuit courts, other appellate courts in the United States that are also writing and thinking about patent law. So we don't always know what's around the corner, what the consequences are of an opinion we write. So therefore, it's I think important to have some humility in terms of the scope of an opinion that a Federal Circuit judge writes or a specialized court judge writes. That's my opinion.
Thank you very much, Judge Chen. And now I'd like to invite Dr. Grabinski from UPC.
Thank you very much. I think for a judge, there are two things essential. The first thing is to make sure that the right to be heard is respected. That means that arguments of a party in front of a judge as part of a proceeding before a court, that these arguments are heard and understood. And it is, of course, also important that the judges know about the law and to apply once they have heard and identified the facts that were brought in front of the judges. And the European approach to this in the field of particularly patent law, but also to quite some extent IP law in general, is that there are specialist courts, or at least specialist parts in the general courts that deal with these litigation. For example, in Germany, with regard to infringement, it is district courts that have jurisdiction, but only a few, not all. And in the district court, it is a specialized division that takes care of IP litigation and particular patent litigation. And there is, when it comes to validity, even a court that is a federal patent court. So one court that decides on this, a specialist court. In France, for example, all the patent cases on the national level go to one court, the Paris court. Before, 20, 30 years ago, it was different, but after a revision of the French law, it developed in that direction. And the same is true for Italy. There's only a few district courts that have the jurisdiction to decide in patent cases. And now I could go on to Sweden, to other European countries. And as there is an interest in Europe to have a court also on the European level, in parallel to the single market concept of the European Union, there has been a common court dealing with patent cases that has been discussed essentially since the 1950, the 50s of the last century, and it finally became a reality with the UPC. So there's quite a strong belief in Europe that specialist courts should deal with these with patent cases because of the complexity of the cases. It is about technology. Technology is developing all the time, and judges have to be open to it and have to understand about the cases. And it is, in principle, it is. I think any judge can understand what a technology case is about, but it would certainly take a judge who is used to do with these cases much easier, much more efficient to deal with these cases, rather than a judge who has really to start working on the first case, and then the next case again is a general civil law case. So I think this is the reason why in Europe there's it's more the specialist court approach. At the same token, I would say it is, of course, important also for the specialist judges that they do not forget about general principles that underlying all fields of law. So a contact and an exchange of minds with judges in the other fields of particular civil law is, of course, also important. That they do not start to develop their own law that is no longer in touch with the general tendencies in civil law. But there are ways to make sure that this is going to happen by exchange of views, by reading not only as a patent judge, not only reading patent decisions, but also decisions in other fields of law. And of course also by international exchange like this one, to learn also other approaches, how this works. So in general, the European approach is in the direction of specialist courts, and they justify because it's a very particular area, it's more efficient, but they should not lose touch with the other fields of law at the same time, and that's also important. Thank you.
Thank you very much, Dr. Grabinski. And thank you very much for intriguing comments. And now I'd like to invite Mr. Anonaka from the Patent Office to talk about the roles of the Patent Office. Thank you very much. So now I'd like to talk about our role of the Patent Office as an administrative office. And now today I spent quite some time to talk about improving the quality of the Patent Office in general. And then for us, first of all, as the first step of the system, we are to improve the accuracy of the rights. And also now there is an option to go to the court later on. But then at the time when the parties come to the JPO, we are to make sure that we do utilize our technical and legal perspectives. And also Mr. Honda talked about a standard setter, and the court shows us the standard. So we're using that, we are to grant the rights that other parties deserve. So that's an important role for us. And then if certain people have different opinions to the judgment made by after the examination, then they are able to appeal for it. And for that, we do use the panel of several examiners to make the appropriate judgment. And also another point, in order to let the parties really utilize the rights that they acquire. We just talked about support innovation, but as an administrative office, we are in a position to be able to provide necessary support for this purpose. And JSIP today, that is, of course, one opportunity, and we are to promote communication with international organizations, and then disseminate what we learn to the general public. So JP would like to make contributions. And as the office supporting IP, JPL would like to continue to work with WHC to meet up to expectations. Thank you. Thank you very much, Mr. Nonaka. So now, from a user's perspective of the video, I'd like to ask Ms. Sakara for your remarks. Yes, so I'll be rather brief. In my experience, in Japan, we don't really have truly technical judges. But then I feel that there's been a fair judgment, and there's a system of the specialists here in Japan that's quite unique. But instead of thinking about changing our system drastically, during the process of the procedures of the examinations, I think that it will help us if we can communicate our opinions in a more interactive ways. So to increase the level of understanding among the parties and judges, and then we can be more predictable. And then in IP disputes, there are specialized, there's a requirement for specialized knowledge, but this is a dispute after all. So for the judges, we are even more than a specialized knowledge. The fair and equitable legal mind is required. And then today we are getting to learn about the system in other countries. So the system here in Japan should be modified for the convenience of users, and that's what I'm hoping to see. Thank you very much.
Now, from patent attorney's perspective, Mr. Kurokawa, please. Thank you. Yeah, each region shared many things, like a special court for IP. Based on many ideas, many initiatives have been run. And also, some initiatives will be newly run. I want to show my respect to that. If possible, listen to users. I hope that you can also share more higher level of expertise in terms of technical expertise. I hope that the valid decisions can be made from technology perspective in IPHC. You have some specialists, such as examiners or advisors. Also, you have a technical detailing sessions. You can use them all in the best balance so that you can have more technical validity. In terms of the role of IP court, from user's perspective, like a specific guidelines can be shown or demonstrated for us. For example, in terms of the inventive steps examination, anyone involved in patent should make a start of that. And this is also very like eternal theme at the same time. Like in terms of inventive steps in the IPHC in Japan, like sometimes necessity of motivation is shown. Also sometimes like some guidelines, specific guidelines are dedicated. Again, these judges also impact the vision of the guideline for examination in JPO. Also, predictability in the industry is improved. In the US, as I heard, like KSR's cases also show very clear like obviousness decision. That's all from me. Thank you. Mr. Kurokawa, thank you so much. Well, unfortunately, we are approaching the end of our allocated time. And now I'd like to conclude the plenary session, the first half of day one of JSIP 2025. Now, on behalf of the organizers, I'd like to invite a few brief closing remarks. May I first ask Mr. Masuda? Thank you so much. Today, to celebrate the 20th anniversary of IPHC in Japan, we invited international judges to organize this type of symposium to learn judiciary obligations in the last 20 years. And we've been sharing information, opinions. I really appreciate all of your participations. I believe that you've been very busy in your regions, but still you came to this symposium in Japan, like Mr. Han from Korea and Mr. Gravinsky from Europe and Mr. Chen from the US. Thank you so much for your very insightful presentations. We learned a lot from them. Mr. Sagara, Mr. Kurokawa, Ms. Sagara, Mr. Kurokawa, yes, they gave us very encouraging messages for IPHC in Japan. So today we've shared information and opinions. Personally, I received very great encouragement. Also, those who are watching this session on the web, I believe that they know more clarified visions about the journeys that IP Court will follow in the future. Thank you very much. Thank you very much, Ms. Masuda. Next, may I invite Mr. Nonaka to give his remarks.
Well, thank you very much. So since our time is limited, I feel exactly the same way as Mr. Masuda, and I'd like to thank you very much for all the participants today. And also today we are marking the 20th anniversary of IPHC, and for the patent office as well. Well, this is a good opportunity for us to look back on what has been achieved. And today we're able to talk about IP assets from different countries, and that was a great learning for me as well. And I am hoping that this is going to continue going forward. And then tomorrow, that will be the JSIP Day 2, and that is to be chaired by the patent office. So I'm hoping that we are able to further increase our mutual understanding. So waiting to see you again tomorrow. And thank you very much again for today. Well, thank you very much, Mr. Nonaka. So this marks the end of today's event. And thank you very much for your attention. Now we'd like to close the panel discussion on the international trends in IP fields and the roles of specialized IP courts. And thank you again for the panelists for joining us.